The information and opinions expressed on senior living are neither legally binding nor the responsibility of this cable system. The following program is made possible by a generous donation from the Veterans Assistance Association.
Hi, thanks for tuning in. My name is Patrick Simasko and I'm an elder law attorney, and this is Senior Moments. The first section that we talked about power of attorneys, medical and financial power of attorneys. This session we're going to be talking about how to avoid probate, a death probate. Mom or dad passed away and we want our assets to go to our family members without having to go through probate. And there's different ways to do that. I have been an elder law attorney for the last 20 years, I guess, and I've been doing estate planning for that time, and I've done a number of probates in my life and hundreds of estate plans, and I've seen a lot of the pros and cons and the different plans that people have implemented. So we're going to be talking about how do you protect your assets if you're worried about your loved one passing away. And thanks for the audience for showing up. If you have any questions, please feel free. The first segment we talked about is I get sick and I want someone there to make my medical and financial decision. Now we're worried that mom's going to pass away. How do we get our assets from mom down to the beneficiaries without having to go through probate? And there's different ways that you can do it. One way is joint accounts, joint bank accounts. One way is beneficiary designations. And the third way is a living trust agreement. We're going to talk primarily about trust agreements because that's a real hot topic in the community, and we're also going to be answering any questions that you have about joint accounts or the way that many families have their estates set up. So the first question that always comes up is, what's the difference between a will and a trust? Okay, a trust is a document that says, while I'm alive, I'm the boss, I'm the trustee, and I'm in charge. If I should get sick, I pick someone to make decisions for my trust on my behalf. They're called the successor trustee. If I pass away, that successor trustee becomes in charge of the trust, and he distributes those assets to the beneficiaries the way that you have it set up. When you have that trust agreement and your assets are in the trust, there's no need to go through probate. A will is a separate document altogether. It's one of the documents that we need in our estate plan, and the will says that if I pass away, a typical last will and testament, I want my things to go to my husband or my wife or my children. That will only comes into place with assets that are in your name alone. If you have a joint account, if you have a beneficiary on your life insurance policy, it goes to whoever's on that joint account independently of your will. Joint accounts supersede the will. Okay? So if you want to avoid probate using joint accounts, and I have my account, my will says I want everything to go to my 5 children, and I have my account set up in my one child's name, when I die, that money goes to that one child. That child does not have to give it to all the other brothers and sisters. Okay? Joint accounts supersede the will. With the estate plan that we do for many families, there's 4 documents: medical power of attorney, financial power of attorney we talked about before, a last will and testament, and a trust. When you have a trust agreement, you want to have your assets titled into your trust, and then you pick someone to be in charge. If you want your 5 children to get the money, you pick your one person to be trustee. If you die, it's that trustee's job to split the money up between the 5 children. You don't have to ask her permission. Will you voluntarily give the money to your brothers and sisters because your name was the only one on the account? So it's her responsibility to do that. It avoids probate, but it also makes sure that the money's going to be going to your beneficiaries the way that you have it set up. We had a question last time about my will, husband and wife, and my husband just died. Do I need to probate his will? No, typically, because mom and dad's are on all the accounts together. You're joint owner on all the bank accounts. You're joint on the house, on the deed to the house. You're on the life insurance as beneficiary. If dad passes away, do we need to use his will? No, as long as you're on all the bank accounts with him. If he has an account in his own name, would you have to go through probate? Yes, you would. You would absolutely have to go through probate. How does a trust work? A living trust agreement. And I like to use an example as a corporation. When you create a trust, you're creating your own little family corporation. In a corporation, let's call it the mom and dad corporation or the mom and dad trust. Corporation owns assets, owns real estate, bank accounts, stocks, bonds, mutual funds. Your trust will own your assets, your house, your bank accounts, your stocks, your bonds, your mutual funds. With the corporation, it's run by the president. The president has authority to act on behalf of the corporation. While you're alive, you're the president of your trust. You're the original trustee. You're in charge. You're the boss. If you get sick, the trust agreement usually says, I pick my daughter, or I pick my son, or I pick one of my loved ones to be the successor trustee. They have authority to administer your trust, and you become the beneficiary of your trust. They have to use your assets to take care of you. Okay? If you pass away, that successor trustee has the authority to go into your different accounts, goes in, and they go to the bank. Mom died, and I want to get access to her trust accounts. The banker says, prove that she died. Here's a death certificate. Prove that you're the trustee, the successor trustee. Here's the trust document. Prove that you're married. Here's my driver's license. When you do that, you have access to those accounts immediately. You can distribute the assets. You can pay the bills right immediately. You don't have to wait through the whole probate process to get the bills paid or distribute the funds to your beneficiaries. So it avoids probate, and it avoids all the problems that joint accounts could have. Does anybody here have joint accounts set up right now with their family members? Okay. Did you have any, I think you were talking about a question, Tony, before about joint accounts. What was that question?
The question is that I have all my accounts. They're not joint accounts. The only joint accounts I have with my daughter is the checking account. All my savings, all my stocks, all my bonds, all my mutual funds, they are beneficiaries, not joint.
Right.
I have the only name there. I'm the owner. So do I still need a trust, even though I've set up all the beneficiaries the way I want it to be set up? Do I still need a living trust? Or is the way I have it is the right way and they don't have to go to probate?
It's hard to give a good answer on that. But first of all, if your daughter is on your bank account, is joint with you, the only thing that your daughter has access to is that joint account. Okay? She doesn't have access to your bonds and your stocks and your mutual funds. So if you ever need funds to pay for assisted living or a nursing home bill, or you need funds, if you don't have a power of attorney, she doesn't have access to any of those accounts. Well, that's very good. So you have that. Now, if you pass away, those accounts are set up that it's going to be going to the 4 children. Okay, so who owns, that will work fine. But usually those accounts are set up that it goes 1, 2, 3, 4, 25% each. Now let me ask you, if your daughter passed away before you, would you want her share to go to her children?
Yes.
It's not set up that way.
Yes.
No, it's not. Because it's set up that it goes 4 ways. If 1 dies, it goes 3 ways. If 2 dies, it goes 2 ways. So as long as all your children outlive you, that would be fine. But if one passes away before you, that person's share doesn't go down to their children, it goes to the other brothers and sisters. And now you're relying on the other brothers and sisters to distribute the money to those children. Now, how old are your grandchildren?
10 and 12.
Okay. If your grandchildren are that young and they're going to get money, are you allowed to give grandchildren money at 10? You got to go to probate court and have a conservator. That's not a good idea. With the trust agreement, it says, I want the stuff to go to my 4 children. If my daughter dies, her share goes to her children. But have a trustee, someone that you pick that you trust, and they're going to take care of the money for the grandkids. Hold on to that money till the grandkids turn 21, 22, 25. Use the money for their schooling and education before they reach that age. General health, welfare, safety, and education. So, if all of your children outlive you, great. If one of the kids pass away before you, it's not set up the way that it should be set up. Is one of your children going to die before you?
No.
Hope not. But can we say that? You just never know. So the beautiful thing with the trust agreement is you plan out for these contingencies. You can plan out things that may happen in the future. So we're going to get back to more questions right after this break for Senior Moments. Thanks for tuning in.
My dad is my hero. He goes into places people want to get away from. He makes everyone safe. But the best thing he can do is come home.
The U.S. Fire Administration reminds you to protect yourself and firefighters. Have smoke alarms on every level and near sleeping areas. Test them monthly. Change batteries as instructed. Install sprinklers. Do your part to get out before firefighters have to come in.
Massive earthquake has rocked the city. West Metro Disaster Peace Region has ever witnessed.
When a disaster strikes, time is a killer. The hours following are critical. Time is a killer. The hours following are critical. The UN Central Emergency Response Fund jumpstarts relief efforts, which saves lives. Help us help in time. Donate now at rapiddisasterrelief.org.
We're just talking about whether or not we should have a trust agreement if we have our children listed as beneficiaries on our accounts. And since we took the break, there's a lot of other questions that came up. Tony, did you have any other questions about?
Yes. You said that in case my daughter died, precedes me in death, then it would still have to go to probate because she's a beneficiary. She would have to go to the next ones. Instead of 4, it would be 3 if she died before me. But my question is, what about if when she dies, then I'll go and get another rearrange the beneficiaries?
You could change it. Sure, you can absolutely change it before it's too late. And it's too late to change it is if you pass away or if you become incapacitated. Say, sadly, it was a car accident that you and your daughter in, and you got hurt really bad, and you couldn't change it. Number one. Or number two, let's say that you had all the time in the world, your daughter passed away, and you want to give her share to her 2 children. Now, if you list those children as beneficiaries on the account, and they're 10 years old, right? If you pass away, they have to go to probate court and have a conservatorship appointed for them to get the money. Now, that conservatorship is going to last from the time that they're 10 years old until the time that they're 18 years old. And when they turn 18, they get all the money. Now, what's the rule? You're smarter at 10 than you are at 18, right? And what happens, money does horrible things to young people. So when they get 18, you want it to be used for education. Do they have to use it for education? No, they could use it for education, alcohol, drugs. I could have many horror stories how money does bad things to young people. So how do you avoid that? If you're going to do it, you want to have their share placed in a trust agreement. Have it held in trust until they're 21 or 22 or 25, and have someone there, maybe one of your other daughters, to be in charge of their money, invest it for them, and use it for their benefit. Buy them a car if they think it's important. Pay health insurance if they think it's important. Tuition, room and board. All that is available for them. Hold on to the money until you think that they're old enough to manage it on their own. So with the trust agreement, it solves both problems. If you set it up now and your daughter's alive, it avoids probate. You set it up now, if your daughter passes away before you, it goes to her children. You don't have to worry about the other brothers and sisters. You set it up now, if it goes to the grandchildren, they don't have to, you don't have to worry about them doing foolish things with your money, because that is just the most horrible situation, and I've seen it many times. When these young people get money, what can happen to them? It's just devastating to a family. So keeping it locked up, keeping it protected by a loved one is very important. Okay. Now that's the beneficiaries. A lot of people, you have stocks. You can't have a beneficiary on stock certificates. You have joint bank accounts. Let's say you have 4 children on your joint bank account. Mom is on it with my 4 kids. Who owns the money in a joint bank account? Does anybody know? First one to get to the bank. First one to get to the bank. It's the first one to get to the bank while you're alive. It's the first one to get to the bank when you pass away. So we have many cases where daughter's on the account, she starts taking money out. Son's on the account, he starts taking money out. Or, like I said earlier, you have the best kids in the world, but if they lose their job and now there's a bankruptcy, that bankruptcy court has access to your money. If there's a divorce, that court, the divorce court has access to your money as part of the divorce settlement. So those are things that prop up. Their problems become your problems. Okay? Any questions on that?
I understand it's important that my parents and my grandparents create a trust, but someone my age, is it important that I set something up now?
Well, it all depends on, first of all, do I need a will if I have a trust agreement? For younger people that have children, a will is the place that you want to pick to have guardians for your children. That's the only spot that you can identify. I want my sister to take care of my kids. I want my mom to take care of my kids. So you have one person in the will named guardian, but you may not have that same person be in charge of their money that they're going to get within a trust. Life insurance. For younger people, if you have assets, trusts are good to have because you could pass away. When do you need a trust? Before you die. And you don't know when that ever is going to be. So that's the thing that you just have to watch out for. But for younger people, great idea, medical and financial power of attorney, a will if you have minor children. Okay, good question.
What about if you own a home? Is that important then to have a trust?
Very important. A lot of people use quick claim deeds to avoid probate on their house. Okay? It can work great as long as all the stars line up again that we just talked about. If you put your house in your name and the 3 kids' names, if you want to sell the house, they have to sign off on the house. If you want to do anything with the house, remortgage it, they have to sign off on that house. You don't need their signature to put them on the house, but you need their signature to take them off the house. Okay? If you're going to sell it, and we've had many cases where mom puts one of the kids on the house, because they're going to live happily ever after together, and all of a sudden, mom can't get along with the daughter-in-law. That's the in-laws to outlaws rule, okay? So now mom has to move out, and she says, okay, I want my house back, and the son doesn't sign off. So now mom's living in an apartment, and the daughter-in-law with her son is living in the house. Those are things that are real scenarios that pop up all the time. With the trust agreement, you don't have to worry about that. You have it, you create it, you're in charge until you pass away. So joint ownership can work great. It avoids probate as long as everything works out. But if the what-ifs pop up, that's when the problems arise. And that's when there's family disputes. So, good question.
Yeah, as I had told you in a previous program that my husband had passed away just recently, he had had some stock from Chrysler that went into Merrill Lynch. My name was not on it because it was Chrysler. Now, what happens now? I mean, everything else, we'd had joint bank accounts and all of this stuff. And so what about his stock?
So he had stock certificates in his name alone. Now, you also had a power of attorney, right?
Yes,
okay.
He had a power of attorney, and I also do.
That's the perfect example to bring this all home for everybody. First of all, when you have the power of attorney, it only lasts as long as Dad's alive. He passed away, so now you don't have authority to sell the stock. You could have, had you realized that before he passed away, you could have sold the stock and got the money out of that account. But now that it's in his name alone, if you would call up the stock company and say, hey, I want to sell it, they're going to say, you're not Dad, right? And there's no beneficiaries on stocks. So you don't have authority to access that money as beneficiary, and that's what probate is for. Is if it's in Dad's name alone, the probate court has to pick somebody to be in charge of that estate. So you have to open up a probate. I hope the camera saw the eye rolling. And it's sad, and you saw my eyes rolling before when I heard that, is you have to open up a probate estate to have authority to access those funds, to get the money out of Chrysler's, to get the money out of a life insurance policy, to get the money out of an account that was just in Dad's name. Now, the question is going to be, how much is that stock worth? Is it worth a lot of money, or is it worth just a little bit of money? There's different levels of probate. There's a small estate, there's an informal probate. So if the value is under $15,000, it's a pretty straightforward, easy thing to get that asset out of probate. If it's more than $15,000, you have to go through a full-blown probate and get it and pay the filing fees and all that goes with it. So that we'll talk about that afterward if you want. Yeah, so that's a prime example is why you think that just because you're married, you have everything covered, and you have these little things that can pop up. Now, if you were joint on that stock, joint accounts don't avoid probate, it delays probate. Mom and Dad's name, Dad dies, it's Mom's now. Mom has to do something with it before she passes away, or she has to go through the kids will have to go through probate for Mom. So it doesn't avoid it, it just delays it. So now's the time that you should really take a look at your total estate plan to make sure that we have everything covered, which is your house, your power of attorneys are up to date. That's always a good time to take a look at it.
You were talking about younger people setting up trust agreements. What happens if I do that now and say 10 years from now the person that I picked to be in charge, I no longer want them to be in charge? With trust agreements, they're always revocable or amendable. You don't really want to revoke a trust, you want to change it. You want to change who your beneficiaries are, you want to change who your trustee is. And when you set up the trust originally, you want the what-ifs. What if my daughter dies before me? What if my son can't be the trustee because he's in Afghanistan now and he's not accessible? So you want an order to cover the what-ifs.
But if you ever want to change it or update it, you can always change it or update it for a revocable trust. That's the nice thing about the trust, is if you have 57 different accounts, everything is in the trust before you get sick. Everything's in the trust. Now you want to change it. You don't have to go back and change 57 accounts. You just change the trust one time. It's easy, quick. The only thing that you don't want to have in your trust is your IRAs or your 401k plans. That's a completely different show. Those are called qualified financial investments. Those can only be owned by an individual. So don't be running out there putting your IRAs in the trust. Those you have to talk to your attorney or your financial planner about that. So, any other last questions on trust? I know this is a hot topic. Last one?
Yeah, quickly. The quick claim deed on my house. I have 4 names, my kids' names, on the quit claim deed. So when I die, they sell the house altogether and they divide the money according to to the percentage that I stated.
Right. They can sell the house. Now, is that the right thing? You have 4 kids, and one kid says, I'm not selling because I want to live there. Can the other 3 force them to sell? The answer is no, and we're going to talk more about that in the next show because we're running out of time. So I hope you found this show interesting. It's a million questions that you have that we can answer in this half hour, but what we want to do is dedicate time in the next show to get back to answer some questions. So if you have any questions, email me at questions@simaskolaw.com. Call my office. Or if you want to show up and sit in on the audience, please do it. We love to have people. I work a lot better with questions and answers than just on a lecture series.